going.
As I was saying.
I was just going to deal with some points arising from some instructions to deal with the consequentials SI. I was then going to wrap up on the consequentials SI and then deal with the grounds of appeal. So could I just make a general point about the consequentials SI and the grace period SI? And it's this, that they are intended to work together. They don't work in silos. So the consequentials SI is intended to be specific legislation about considering and granting applications for residence documents after the end of the transition period. And to show just one provision to make that good, that they're designed to work together, could I just invite the court to look again at paragraph 3.3 of schedule, paragraph 3.2 of schedule 3, and there the court will see that this regulation is the legislation that deals with considering and where appropriate granting an application for a family permit which was validly made after commencement day in accordance with the EA regulations as they are continued in effect by the Citizens' Rights Application Deadline, etc., i.e. the grace period SI. So that's an example, because you can't, under the consequentials SI, make an application for an EEA family permit after the end of the transition period. Because Regulation 12 is not one of the preserved provisions, but I showed the court that it is a preserved provision in the grace period SI. So that paragraph 3.2 can only apply to somebody in the grace period.
Sorry, I'm looking at page 37. I thought it was listed at 5, or am I now completely in the wrong one? Page 37 for...
Yes, your lordship's in the grace period SI. That's exactly the point I'm making, that it is preserved.
It.
Yes, so it's preserved for the grace period cohort. By...
Oh, I see, they are continued in effect by, right?
Yes, and then if in the grace period SI, look at Regulation 6B, Regulation 12 is continued in effect. So that allows somebody within the grace period SI to make an application for an EEA family permit after the end of the transition period. How is that application to be considered and determined? Not under the grace period SI, but under the consequentials SI, because the consequentials SI is the specific legislation which regulates consideration and granting of applications after the end of the transition period. That's simply not done in the grace period SI. So they are intended to work together. And that's why I gave that example of somebody, when your lordship asked me about Regulation 20, well, why is that done? Why is that done by the consequentials SI? It just is. That's the way it was done. It was organised so that for anything to do with considering and granting residence documents, that's regulated by the consequentials SI. And the consequentials SI is therefore covering two different cohorts. It's covering people who benefit from ongoing residence rights under the grace period SI, and it's also covering application by people who don't. So can I then, that in my submission is a simple, an express example on the face of the legislation in paragraph 3.2 about them working together, and about this being the special legislation, the consequentials SI, for granting residence documents. And then importantly, and I want to just re-emphasise this, that paragraph 4,
of the Schedule 3.
Of Schedule 3, yes.
Yes.
Paragraph 4 has got a very special wording, and it can be compared to the grace period SI. What is the purpose of the regulations that are specified in the following provisions? Paragraph 4.1. The provisions of the EEA regulations specified in paragraph 6 continue to apply with the modifications specified for the purposes of determining whether an application referred to in paragraph 3 should be granted. So what that means is that there is no freestanding right of admission conferred by the consequential SI. Regulation 11 is only continues to apply for the purposes of determining whether an application referred to in paragraph 3 should be granted. That's the only purpose for which it is continued. The second point to make in relation to both paragraphs 3 and 4, but in particular paragraph 4, is that it puts the focus on the determination, determining whether an application should be granted. So the determination, obviously then, is the date the determination is being made. And the question that the person deciding the application has to ask themselves is this: would they have a right of admission at today's date? Because paragraph 4.1 says that regulation 11 applies for the purpose of determining whether an application referred to in paragraph 3 should be granted. So should I grant this application? Right then, let me look at regulation 11 for that purpose. But somebody can't, who's outside the grace period SI, just turn up at the border and say I rely on regulation 11, because Schedule 3, paragraph 4 says it's only continued in effect for the purposes of determining whether an application should be granted. So that's that. The reason that
it is continued in effect with the force that it had prior to revocation, and 11.5e is your problem.
Yes, and I'm going to come on to that, because we think we've been unfair to the drafter, because we have in fact think having just put our heads together that actually we're going to give an example of a scenario where we think, or at least the drafter would have thought, that it would apply and it would work and consistent with what we've said about regulation 20. But could I just make this point about focus on determination, that under EU law and under the 2016 regulations, it's always been the position that you look at things as at the date of the decision, not at the date of some prior application. And that works both to an applicant's benefit and against them. It will often be the case, and we will find that I think there is case law about this, certainly the practice, that when somebody would turn up to their first tier tribunal hearing to argue about their rights, there was no issue about them introducing all sorts of new evidence, and indeed evidence which wasn't before the decision maker, because rights of residents are declaratory. You're looking at the position as at the date of the decision. And this, we say, in focusing on the purpose of determining whether an application should be granted, puts the focus on the determination, not what the position was at the date of application. So what this is doing is saying this applies to the decision maker. Inevitably then, that means you're looking at the date of the determination, and that's consistent with the broader scheme of EU law. So that the decision maker has to ask themselves, if they're applying regulation 11, and let's turn up regulation 11 now, page 51 to 52, and particularly 11.5e. I am the decision maker. I direct myself that I'm looking at regulation 11 for the purpose of determining now whether this application should be granted. And what regulation 11.5e says is this: is accompanying a British citizen to or joining a British citizen in the UK, and P would be entitled to reside in the UK under regulation 16.5 were P and the British citizen both in the UK. Well, one cohort of Zambrano carers would be entitled to reside under regulation 16.5 because it's continued in effect for them. Another cohort of Zambrano carers, i.e. those who are trying to say I want to come in January 21, who at the date of the decision do not have any substantive right of residence, would not be entitled to reside.
But you're not looking, but the problem that you've got is all the regulations that you've shown us in Schedule 3 seem to be doing the opposite. I understand that that may be the normal position, but right from the very beginning they defined the regulations as the E regulation, and unless provided otherwise, the regulations as they had effect immediately before they were revoked. So whenever the decision maker makes a determination, he or she will say, right, what effect did these regulations have when they were in force? And the answer is, somebody, as at the date they were in force, would have been entitled to remain.
But there's a distinction then between what the regulations said on the 30th of December 2020 and looking at the person's position on the date of 30th of December 2020. We say that that's not right. You may apply the law as it stood on 30th of December 2020 as applied by these regulations, but you look at the person's position as at the date of the determination. You don't. The fact that paragraph 1.1 takes you back to the regulations immediately before they were revoked doesn't mean that you look at the person's facts as at the date that the regulations were still in force. What you're looking at, because it's focused on the determination, is the person's facts.
But the facts are that the person is A, a primary carer, B, of a British national, who C, wishes to enter the United Kingdom, and D, would have been entitled to do so under the regulations as they've been in force. The facts haven't altered at all.
And E does not enjoy that right as at the date of residence because it's been revoked in their case. Well, your lordship has
anyway,
my
we have the argument, yes.
Yes, you have my submission. So, can I just give an example of when we say that reference to Regulation 11 in paragraph 6 would apply? So, take this example. A Nigerian national who is residing in the UK with a Zambrano right on the 1st of November 2020. So they're covered by the grace period SI. They then have a family emergency. They go home to Nigeria. And then on the 18th of December, the same date that the Rafius made their application, they apply for an EEA family permit because they want to come back and they want to continue exercising the right that they have already enjoyed. The decision maker gets their application, their EEA family permit application. The decision maker then applies the consequential SI in order to consider and determine that application. And what the decision maker is required to do is consider whether the applicant would, using the language of Regulation 4, apply Regulation 11 for the purposes of determining whether an application referred to in paragraph 3 should be granted. And so, in that example that I've given, there would be a use for Regulation 11 because the consequentials SI is all about considering and determining applications. So it doesn't help to pull in Regulation 11 from the grace period SI. The decision maker has to ask the question, let me apply Regulation 11 for the purposes of determining whether an application referred to in paragraph 3 should be granted. And the answer in the situation I've given is that yes, they would meet 11.5 because, let me just go back to the language, they would be entitled to reside in the UK under Regulation 65 if they were in the UK because they're given that right by the grace period SI.
But sorry, that I really can't follow that because E is accompanying or joining. It's not, and you're here already.
No.
You're applying it to a completely different factual situation, namely somebody who's here.
But that's always the case in Regulation 11 because it's about a right of admission.
And you're talking about someone who's joining. So in the example you postulate, the person was enjoying the Zambrano right because he/she and the British citizen child were both in the UK. Zambrano carer has to go back to Nigeria for a family emergency, but would be entitled to reside in the UK under 16.5 if he and the British citizen were both in the United Kingdom. So it's making a hypothesis in favour of the person who's had to leave for the family emergency in order to enable him to make that application.
And they would have a right to, they would be entitled to reside under Regulation 16.5 because the grace period gives them that right on the date that it's determined. Say the application is determined on the 1st of February, the decision maker thinks, well, should this person be admitted? Would they have a right to reside were they here? Yes, they would, because they've got it under the grace period SI.
I thought the grace period SI was all about applications for EUSS.
It's not about that, it's about the rights that people enjoy if they have made such an application. And pending, in the example I've just given, they would still be in the grace period and wouldn't need to have made such an application. But it's, in my submission, it's not, the context is that it's about people who are making an application or have made one, but what it does substantively is decide what rights they enjoy in those circumstances.
I'm just looking at 4 again. This regulation has effect. This is 37. And it says this regulation applies to a person, the applicant, who's made an in-time application, and thus defined in 6. And an in-time application is an application for leave to enter or remain in the United Kingdom by virtue of residence scheme immigration rules. I just don't see anything in the grace period regulations which suggests that the regulation continuing Regulation 16 of the 2016 regulations applies in other situations.
But it says, the Regulation 4.3, the provisions of the EEA regulations specified in Regulations 5 to 10 continue to have effect with the modifications specified in those regulations in relation to the applicant during the relevant period. So these are people that continue to benefit from residence rights under the 2016 regulations, despite the fact that the UK has left the EU.
Yeah, but the applicant is the person in 2, isn't it, in 4.2, in relation to the applicant during the relevant period. And the applicant is a person who has made an in-time application, and that is always by virtue of the residence scheme. It's entirely connected to whether you work out...
It is, because that's the gateway to enjoying the rights on an ongoing basis, but the gateway is different from the rights that are enjoyed if you pass through the gateway. So what the grace period doesn't do is regulate the making of the use application, because that's done by the immigration rules, nor indeed the making of any other application. What it does is preserve the position of those who are either in the grace period, so they haven't made an application but they need lawful status in the UK. It gives them that by conferring on them a right to reside, or the grace period has finished and they've made their application, and then they're also protected on an ongoing basis until it's finally determined. So although the context is about you're somebody who's made an application on the EU settlement scheme, fundamentally what this whole SI does is confer on you substantive rights. It's just that the cohort who benefit from the rights is defined by reference to the making of an application, or pre the period when an application needs to be made.
So in other words, are the people who could make an application but haven't yet made one, and then after the deadline for applications has passed, the people who have made an application.
Exactly so, yes. And so the Regulation 3 now is effectively just doesn't apply. It stopped having any effect in June 2021, but instead people are now protected, and there are, as I understand it, still people who are protected by Regulation 4.
I understand that, because you've got the period up to the 31st of June, and then you've got the period who they still haven't had their applications determined after June. All I'm saying is, when you look at the actual wordings of this regulation, the grace regulation, everything that it says is by reference to the application of the EUSS scheme. That doesn't of itself connect immediately through to either Regulation 11 or Regulation 20 if you want a family permit or a derivative residence card. It's helpful under the USS, indeed may be required for you to get a residence card to get limited or indefinite leave to remain. But the regulations, when she made them, are keeping Regulation 16 in force for the purposes of the EUSS scheme, and we've just done something different. We're into the 2016 regulations, and that's the other regulations, the consequential saving ones.
I don't agree that they're keeping the provisions in effect for the purposes of the EU settlement scheme.
Well, that's who they apply to in Regulation 4.
Well, those are the people they apply to, but these are not people that need getting this right of residence under the 2016 regulations and the grace period SI it's completely unconnected to the EU settlement scheme. They don't need those rights. The only people that need to get something to apply for the EU settlement scheme are extended family members. The vast majority of people benefiting, in fact, all of the people benefiting from the grace period SI are not extended family members. They're just people who the wing needs to be held while their use position is sorted out. But it's not for the purposes of, in that sense. It's giving them residence rights before something else is sorted out. So I'm not sure I understand.
The only people to whom they can apply.
Yes, but those are the people who enjoy ongoing residence rights. But even for these people in the grace period SI, they are still, the consequentials SI is still relevant to them insofar as they make applications for documents.
And you say that's what keeps the Regulation 20 residence card alive, but not the Regulation 12 family permit card for those people who are Zambrano carers.
Well, I've just given an example of a Zambrano carer who
A returner, yes.
who can rely, and that's because he falls within the grace period SI, and therefore he enjoys a right to make an application because Regulation 12 is preserved for him, and B, he enjoys a substantive residence right, which therefore gives meaning to the granting of an EEA family permit. For others who don't benefit from the grace period SI, they don't enjoy any rights.
Go on. Go on.
Their applications still have to be considered because they've written them in and asked for them to be considered. But it doesn't mean that they should be granted, because that turns on what underlying rights you enjoy. And I've given a reason, an example of a case where a decision maker would apply Regulation 11 of the 20...
It could apply half of Regulation 7. The joining could never really cover the accompanying for the first time person, could it?
It depends on the
Fact.
Maybe the child went back to Nigeria for the family emergency as well.
Yeah, exactly. So there is. It's just important to understand that they're doing two different things, but they have to interact. The reason that the person who makes the derivative residence card application before the end of the transition period can get it is because that they enjoy a right of residence. The reason that somebody who makes an EEA family permit application who wants to come after the end of the transition period doesn't is because they don't enjoy any right, unlike the example I've just given of the person who already exercised it.
If I understand your submission correctly, what you're saying is the scope of Schedule 3, Paragraph 3 is defined by the scope of the grace period provisions. In other words, if you're not within the grace period provisions, the continuing effect of the regulations, 2016 regulations, doesn't apply to you.
Not. Your Lordship is right in a sense, not so much the scope of it, but because the scope of it is any application which has been made.
No, I understand that, but your application is going to be refused.
Yes,
because you aren't within the scope of the grace period.
Yes,
and it's a right without a meaning.
Yes, there will be others, for example, who aren't within the scope of the grace period SI, but who can rely directly on the withdrawal agreement. For example, joining family members. So those people would be people where to adopt my lady's formulation, where the conditions would be met. Because take, for example, a third country national family member who's got a right to come to the UK under the withdrawal agreement as a joining family member, and their application was made before the end of the transition period, or indeed after it, for a family permit, because that's allowed in certain circumstances. it would be appropriate to grant the application if they enjoyed some sort of right of residence under the withdrawal agreement. So it isn't even, the grace period SI doesn't cover everybody. There are other situations outside the grace period SI covered by the withdrawal agreement where it would be appropriate to grant one of these documents. So the example I've just given, an EEA family permit, somebody who enjoys a right of residence as a family member under the withdrawal agreement. So in that sense, the scope of it is everybody who's likely to succeed, who's going to succeed, somebody who's actually enjoying the right that they're seeking to establish through the application at the date that the decision is made. So, just drawing the strands together, we say two different functions. One is dealing with documents, the other is dealing with ongoing rights of residence for certain people. Regulations 3 and 4 are premised on a decision being made as to whether or not an application should be granted. And I won't repeat the submissions I've just made, but there are various situations where a pending application will be successful, but it cannot be successful where, as at the date of the determination, which will be, in this case it was January 2021, where the Secretary of State has an application, looks at matters at the date of determination and says, shall I grant this application? No, because the person doesn't actually have a right of residence, so I'm not going to admit them. Their application won't succeed. If they do have a right of residence reserved by the grace period SI, then their application will succeed, or by the withdrawal agreement. Now, yes, I accept that regulation, the reference to regulation is not straightforward, but we have given an example which explains why the draft person included it, which was my Zambrano carer left and came back. Essentially, so there's the reference to Regulation 11 on the one hand and all the other features on the other, and we say that the first important context in which this instrument falls to be construed is EU exit. These regulations don't take effect in isolation. They take effect as part of a package of primary legislation which says the UK has left. These rights do not continue as retained EU law, and the only other rights that survive are withdrawal agreement rights. That's the first bit of context. The second bit of context is Zambrano specific, and that is that Zambrano is not preserved either as retained EU law, for the reason I've just given, or as withdrawal agreement law. And we say, in those circumstances, one would need very clear language to preserve a requirement to grant an EEA family permit in order to allow somebody to enter the UK to exercise a right which primary legislation and the withdrawal agreement say no longer exists. We say that would need clear language. And there isn't any such clear language, we say, because what the consequential SI does is not preserve any of the substantive rights. So the fact that it makes a reference to Regulation 11 simply doesn't mean that a decision should be made on the 30th of January to let somebody in to enjoy a right which doesn't exist as a matter of law. And we say when one reads the consequentials SI and the grace period SI together, and no, the drafting is not perfect, for the reasons we've explained in writing, those drafting the legislation were faced with a very heavy task and a difficult task, and there were lots of things happening. So one can certainly forgive them for that. It doesn't help this court, of course, but we say, taken against that statutory context, when you look at the two bits of legislation together against the context of EU law and exit, it's quite clear that there was no intention that simply because somebody had made an application before the end of the transition period, the decision maker should grant them a right of admission when they didn't enjoy any right once they were here. And we come back to the point and the debate I was having with my Lord Justice Lewis about declaratory rights. The whole scheme of Regulation 11 is about looking at whether conditions are met. It's not a free floating right of admission. Now, just to if I could just stop speaking for a minute. Everybody wishes I would. So just to deal briefly with retrospectivity and fairness, we've dealt with it in detail in the written reply, and I'll deal with it in reply if I need to. But we just make a number of points. We say this isn't really retrospectivity in the Wilson sense at all. It's not about legislation changing the legal effect of acts done or transactions entered into before the end of the transition period. It's simply about whether by making an application before a cut-off date, the Secretary of State is required to give you a particular right at a later date. That's not retrospectivity. If there is unfairness in that somebody was hoping to come on the 18th of December and didn't, then that's a direct result of the UK leaving the EU. Now, it also is important to recall that Regulation 11, until the end of the transition period, preserved an ability for somebody simply to arrive here, whether or not they had documents, and claim at the border to be entitled to a Zambrano right to reside. If we look at the Rafiu facts, it's fair to say they were cutting it very fine. They made...
But they're entitled to.
They're entitled to, but they're also entitled... The Secretary of State is also entitled to take a reasonable period for determining applications. They don't get the right. They don't get the right simply because they made the application. They had the option, and everybody had the option, and this is an important part of the statutory context, of coming. They didn't have to wait for that application to be determined.
Oh, but if they turned up on a flight from Nigeria and said to the immigration officer, I haven't got the permit, it's in the post. Let me tell you a story. I wonder what the answer would have been.
Well, I think it's right to say that Regulation 11.4 says that has to be considered by reference
It has
to
to be
its
gone
merits.
through, and there's
And
case law saying that. But it's clear that the expectation is they have the permit. That's why you have the system of permits there. And there may be circumstances when you can't. But anyone who took the chance of flying to England to persuade an immigration officer that their story was backed up without a permit was taking a very big chance on the casino.
But
they were entitled to.
Equally, they were taking a chance by applying on the 18th of December in circumstances where the UK was about to leave the EU, and as of the 1st of January, the Zambrano right had gone altogether. So that fairness is multifaceted. Fairness is that the UK has left. And after the first, let's face it, the withdrawal agreement was very unfair because it basically said even the ones who are here have to leave. The Secretary of State has said, well, we're going to give some people a right to reside, perfectly fairly, going beyond the withdrawal agreement, and said, right, well, okay, people who are here before the end of the transition period, okay. But to suggest that it's unfair simply because the rights have changed is, in our submission, wrong. What has to be looked at is the date of application. Some people are going to miss out. Just like Mr. Chelik, he didn't manage to get married in time. He missed out. People who didn't come before the end of the transition period missed out because the right no longer exists. But that flows as a result of EU exit.
I think you need to move on.
Yes, I'm moving on. That's all I have to say about. That's all I have to say about ground A. Effectively, on the Rafiu facts, they wrote to the Secretary of State. The application said, can we come to the UK in January 2021? And we submit, for all the reasons I've just given, the answer should have been no, because when you want to come in January 2021, that right will be gone. So I can deal briefly now with grounds 1 and 2. we sent in the application form, which hopefully the court has. We can hand it up as well. It is referenced in our skeleton, and I apologise that it didn't make its way into bundles. It was before the first tier tribunal, just to be clear. The other parties have it. So you'll see on the first page, the date of application is 18th of December. Mr. Rafiu describes himself as a dependent rather than a primary carer, and the date that he plans to enter is the 29th of January 2021. Now, for completeness, and I don't know if the advocate wants to refer to these documents, but for completeness, the documents that were submitted with the application are listed at the supplementary bundle at pages 145 to 147. I don't think it's unfair to describe it as a somewhat confusing covering letter, which is dated the 10th of January 2021 at page 148. And then lots of material in that supplementary bundle.
Sorry, I've written down it. Supplementary bundle 145 to 147. I think
Yes.
those are the pages that
So
were submitted.
what that should show at 145 to 147 is a list of documents that were submitted with the application. So it looks like lots of little squares on a page.
I just got rent receipts at 145 to 147.
Oh, is your lordship looking at handwritten pagination or typed?
Neither, block stamped on.
Look. So is that the Rafiu bundle supplementary?
Oh no, I mean Ahmad, sorry.
Ah.
Always help. Oh, they both are made. Oh, here we are, sorry. There's the third one. Sorry. Oh, no, I've got it. Yeah,
So I'm just giving you the page references.
yeah that's the list of
documents.
documents. No, I've got it, yeah.
There's a long covering letter at 148, although it's dated the 10th of January, so after the application.
Would it be better, I mean, what's wrong with the Upper Tribunal determination? We haven't looked at the actual decision
Yes,
yet.
so can we
Because we're
go
not
to-
deciding whether he should come in or not.
No, it's just, since they're not here, I thought I ought to show the court what was there. So, core bundle, page 111. Sorry, it's the grant of permission. Core bundle tab 12.
Starts at 104, I think.
Yes, that's right. Sorry, let's just pick the right bundle. So, no issue with paragraph 17 to 19, which sets the decision aside for error of law. Paragraph 24, I just ask the court to read paragraph 24.
Well, was evidence given at the Upper Tribunal on the remaking or just documents?
No evidence given.
Just the documents?
Yes, there is a witness statement.
Yeah.
The witness statement is in the supplementary bundle at page 140. Not from Mr. Rafiu, just from the mother.
Yeah.
So what that says, I can give the paragraph references. There was no oral evidence in the first tier tribunal either. None in the upper tribunal. Paragraph 16 of her witness statement at page 143 of the supplementary bundle. I met my new husband in December 2018 and we lived together looking after my 2 children. Does your lordship have it?
Nearly. Got it.
Paragraph 19, so paragraph 16 we live together. Paragraph 19, all our children live under the same roof and under our care. 20, my husband and I have sole responsibilities over their maintenance, education, finances, welfare, health, shelter. And then paragraph 23 and 24 deal with family life and Article 8. There isn't anywhere in this statement an assertion that were Mr. Rafiu not to be granted a right of residence, that Miss MO, I think we've been calling her, wouldn't come to the UK. And that's the short point. I've taken the court to Velaj.
But sorry, the application was refused.
Yes.
Simply on the basis that the BC, British Citizen Sponsor, the application had been rejected. That was the only basis on which it was refused.
Yes.
And looking at the Upper Tribunal judge's decision in paragraph 24, it said effectively at the end, this was the only reason put forward, and it wasn't contended that the appellants could not benefit from the regulations for any reason other than that advanced by the entry clearance officer in the decisions under appeal. So
Yes.
no other point was made.
In the decision, that's right. That doesn't mean that the Secretary of State can't make the point on appeal.
But you didn't.
No, and we've accepted that.
Mhm.
We've accepted that. What was said in front of the Upper Tribunal is captured at paragraph 11. I can take these two grounds really shortly.
There's a difference between a point of law. I understand, say that you'd be making a point about direct did not include stepfathers, and whatever the facts were, if he's a stepfather, that's the end of it. But this is all to do with the motivation of the family. They want to come together as a family unit, and nobody is suggesting that the family unit could break up and one part go off to England and the other part stay in Nigeria, and that this couple would then be separated, or that the stepfather could come and he'd be separated from his children. Nobody was suggesting that at this stage, and there would have to be a fact-finding inquiry, wouldn't there?
Well, and that's why we say the Upper Tribunal erred, because it didn't do it and the evidence wasn't there to allow it to conclude that the requirement was met. We simply say that the fact-finding task for the tribunal, as set out in Velaj, that the Upper Tribunal didn't do that.
So that's the fact-finding inquiry. You just didn't take the point. The only arguments that were advanced were the decision, the basis of the decision of the entry clearance officer. And the point I think we're trying to make is, isn't it too late now to raise it, because it would require different evidence and a different investigation?
Well, I accept it would have to be remitted. It
Right.
would have to be it would have to be remitted to a fact-finding tribunal to be
Right.
decided. I accept that.
Well,
But we
presumably
still-
your point is that the Upper Tribunal were remaking the decision, so they're the fact finders for this purpose, and they just haven't found the facts that would justify the conclusion.
It's precisely so, my lady. That's my short submission on paragraph 24 of the decision.
But can't they infer it that they want to come together? And if nobody said they're going to split up and they're all together as a family, isn't it reasonable to infer it? Can't they think, well, yep, okay, they'll come together, they're a family.
Well, that is, if that's what the Upper Tribunal did, it's absent on the face of the decision. But we say there isn't room for inferences because it has to be established as a matter of fact.
Well, an inference is a fact. I've got certain facts and I draw an inference from that.
Yes.
Fact A is that they're married. Fact B is they want to stay married. Fact C is I therefore infer that they're not going to live apart.
It's understood,
Yeah.
but it has to be remembered that people don't automatically succeed under Zambrano because they're a family unit.
No, but she
In
says, I'm
Velaj-
satisfied that at bottom, Miss Olive Fialdo would be prevented from entering the United Kingdom and taking care of a British child without the presence of her husband. And she's inferred that fact from the fact that she thinks they are a close family unit on the material before her. And she also infers that he wouldn't come without his own children.
Well, there we are. My
Yeah,
answer to
that's
that
it,
is
yeah.
that the evidence wasn't there to
Cannot
make
draw
the
a-
inference because it's absent from the witness statement and the point wasn't properly tested. It's dealt with, and I don't need to repeat it, it's dealt with in our initial skeleton at paragraph 52 to 56 and our reply skeleton at paragraph 44. Those are the points. and I can take round 1 even more quickly. It's dealt with in our appeal skeleton at paragraphs 43 to 51.
Hold on, that's ground 3. What's ground 2? Just remind me.
Oh, ground 2 is the...
Well, ground 1 of the
I've
original
taken
things.
them. Oh, it's the legal direct relative or legal guardian. So recall that if we're wrong on ground A, that the Upper Tribunal had to apply the 2016 regulations. Those required that he be a direct relative or a legal guardian. He didn't say he was a legal guardian. I've shown the application form. What he said on page 1 was that he was a dependent. On page 8, he described himself as a step parent. And the Upper Tribunal needed to apply that requirement because insofar as the regulations continued to apply, it was only the regulations and not any broader principle of EU law. So the Upper Tribunal had to be satisfied for him to succeed under the regulations that he was a direct relative or legal guardian, because that's a condition of Regulation 16.
I thought you said this morning, Julie, that you weren't taking the fact that it's not a direct relative.
Taking it in terms of saying he couldn't appeal at all, but we have taken as ground 1 the point that he didn't satisfy the requirement substantively. So there's 2 different points.
Let me just put the question differently then. Is your ground this? A stepfather cannot, as a matter of law, be a direct relative?
Yes, that's our position set out in paragraphs 43 to 51.
Because I asked you this morning, I thought you said you weren't taking that, but you are.
I'm sorry not to have been clear. The point I wasn't taking was the point in the regulations. It says that if you don't provide proof that you're a direct relative or legal guardian, you can't appeal at all. We're not taking the point jurisdictionally that he couldn't have appealed at all. But
he just hasn't established because a stepfather can't be a direct family member. Yeah.
No,
a direct parent.
It's in our skeleton at paragraphs 43 to 51. What we explain there is, at least so far as EU direct family members are concerned, a step parent is not a direct family member. We accept it's not defined. The points are as set out in paragraphs 43 to 51 of the skeleton, the appeal skeleton. That's in the core bundle.
Yeah. And that's a big issue. Does that have ramifications in other areas, or is it just now historic on 16.8?
As I understand it, it's simply historic,
on
because each provision would need to be. We haven't done a search for direct relative or legal guardian, but we say it has a specific meaning in this context.
And that doesn't depend on facts, other than the fact that he's not the biological father, he's the stepfather, and that's not in dispute.
Yes.
And again, that wasn't a point put in that way that was raised in the FTT or the Upper Tribunal, but you say there's less of a problem because there's a point of law, no evidence.
And we've included and we acknowledge, and your Lordship has a cogent point in relation to new points of fact being taken in this court, and Miskovich says that that shouldn't happen. We take the point as a point of law in relation to ground 2, which is it's simply not been, the question hasn't been asked, and in relation to this one we say it is a point of law.
Has he been allowed into the United Kingdom since the decision of the Upper Tribunal?
Not that I'm aware. He wrote a letter, I think the court has seen it, where he says, I'm just going to try some other routes now.
You say in your sorry, go on. You say in your footnote 8 that direct descendant only includes a parent. But
yes,
whether biological or legal.
Yes, and that's for the purposes of Article 2 of the Directive, which I accept.
What's a legal parent?
We have the biological or legal, so adoption.
Not a step parent?
No, it quite clearly doesn't mean a step parent. And there's
descendant.
Yes, there's a decision of this court in a case called Laing, where somebody argued they were a direct descendant because they were a stepchild, and that was rejected. But I accept it's a different context. SM Algeria decides that a child under a kafala relationship is not a direct descendant, but they can be an extended family member. But it's established that for the purposes at least of Article 2, stepchild is not direct descendant. This
is an entirely domestic context,
yes,
though, isn't it? I mean, none of that is relevant because the Secretary of State has decided to use the words primary care and direct parent. And we just say that the mother and father were both looking after the child. Mother has a terrible road accident. still wants to be with the child, limited in giving primary care now because of her road accident, and she's got a loving husband that she's been married to for 20 years. The Secretary of State says, well, I'm terribly sorry, he's not a direct parent, he's doing everything for the mother and the child, but they go. That's the meaning, the consequence of the meaning.
What, 2 points. He might have a right under some other provision of immigration law. Second, it may well be that under EU law, the Zambrano right would encompass that situation, but we're looking at simply 2016 regulations.
Gosh.
So, but there may well be other rights in that situation, as for example, has been discussed in other Zambrano cases, that Article 8 often steps in. I mean, if someone had been here for 20 years, they would probably be...
Well, you did never take my example. They're always over elaborate. And as Missy was saying, what about the couple that are together but aren't married?
Yes, there's always...
There's always harsh cases, you say.
Yes, there's always harsh cases. But, so that's grounds 1 and 2. I'm not proposing to say any more about those. I've said enough, I think. As I say, I'm not proposing to reply to Mr. Hobjoy. I propose to reply at ground A or at the end, and obviously I won't repeat things that have already been said. So unless the court has any questions.
No, thank you very much. Yes.
My lords, my lady, can I start with a roadmap? First, ground A, and I'm going to jump straight into the issue of construction under ground A. Second, again on ground A, I'm going to make a number of short points on the consequences of the issue being raised so late. And third, some brief submissions on grounds 1 and 2, which you've just heard submissions from my learned friend on. I'm very much hoping that I will sit down by the end of the day so you can have a clean run on the second appeal tomorrow.
Thank you.
I'm going to focus principally on ground A and the issue of construction. That's the basis upon which the request for an advocate to the court was made. There are, of course, limits to the submissions that I can make on the facts, but I think that there are a few points on grounds 1 and 2 that I hope I can assist the court with. I'm very happy, I should say, as well, to take homework if there is anything that I'm not able to assist you with today, but you think that you would like help on. So, ground A, construction, I propose to take it in 2 stages. First, I will outline what, in my submission, the correct construction of the transitional regulations are. I'm afraid, perhaps unhelpfully, I'm going to refer to them as the transitional regulations because that's now stuck in my head. My learned friend referred to it as the consequential statutory instruments, but it's the same thing. And second, so that first submission is based on the text, object and purpose. Second, I want to address briefly 3 additional factors which I say support my interpretation. That's 1, the presumption against retrospectivity, 2, the presumption against absurdity, and 3, the explanatory memorandum as an external aid to construction. And I say all of those are permissible, given at the very least, and I think there's common ground between us, the text of the transitional regulations. If you're not with me on construction, at the very least they are ambiguous. As I work through the 2 stages, I'll respond to the points made by my learned friend, both in writing and orally. I thought it might be helpful just to stand back for a moment, just to emphasise that there is a great deal of common ground between my learned friend and I. And so I don't need to traverse a lot of what was covered this morning. We agree entirely as to the effect of Brexit as a matter of EU law on freedom of movement. We entirely agree that the withdrawal agreement does not deal with Zambrano carers. And we therefore agree that the relevant inquiry for this court is what the government decided to do as a matter of domestic law for individuals who had applied before the 31st of December 2020. And the answer to that is to be found in the transitional regulations, and so that is going to be my focus. Just 2 preliminary points, and I will develop both of these as I go through, but just listening to the way that the submissions developed. The first point is, and I'm sure, I have no doubt this court has this well in mind, but this court's task is to identify the meaning of the regulations, the meaning of the text in context. And there's been various reference to officials trying to work out what was going on and not being able to identify the relevant individual or the relevant official that was there at the time. I have two witness statements, which I'll address very briefly, from Ms. Cole, which seek to set out her view on what this all means. But obviously, that's all relevant for the exercise that this court is conducting, which is to ascertain what the Secretary of State intended and how Parliament would have understood these regulations when they were laid before it. So that's the first point. And the second point, the second stand-back point, is that there were repeated references to the proposition that there's simply no utility to have a right to enter where there would not be an underlying right to reside. And we say that that betrays the fundamental flaw in my learned friend's position. Admission
just to interrupt for a second, I
Yes,
think that position slightly developed during the course of Ms. Smiles's submissions.
Yes.
So you might need to deal with a reformulated way she put it, if that makes sense.
Well, the point I was going to make was that admission and leave to remain have always been dealt with separately under the regulations. And what we are concerned here with is admission. And we submit, or I submit, I'm here by myself, I submit that it is perfectly explicable that the Secretary of State may have decided to deal in this instrument with admission and then deal later with what would happen to individuals once they had come here. And that is exactly, and I'm going to spend a little bit of time on this, that's exactly what happened in relation to the concession. So there were individuals who, on my learned friend's case, would not have had a derivative right at the time they applied, but they're here, and a concession has now been made to give them leave to remain. And one can see the artificiality in drawing the line that my learned friend seeks to based on this point about absurdity. If one thinks about the individual, because the line is date of determination. If an application was considered and determined on the 30th of December or in the morning of the 31st, and the EEA family permit was granted, and then they arrive on the 1st of January, well, they're going to be in precisely the same situation, but it would have been granted. There's no suggestion, no evidence that those applications were being refused if they were determined on the 30th, even though that person on arrival, if they arrived on the 1st of January, would not have a right to reside. They're just the headline points. I'm going to come back to develop both of them, but I just thought it was helpful to introduce them because they were points that came up repeatedly. Starting then with the regs, I don't need to go back to the 2016 regulation. My learned friend went through it very fairly and fully. I did just want to make one brief observation on the 2016 regs in relation to this gap that was identified. It was about regulation 16.6, which you'll recall that's the regulation that provides for dependent children under the age of 18. And I spent far too much time over the weekend trying to work out how that cohort got an EU family permit under regulations 11 and 12. And my learned friend has very helpfully acknowledged that there's just an error, there's just a mistake in...
Yeah, it's not really helpful for councillors to stand up and say, ignore the law, it's a mistake. We can't, because we're a court.
Well, that's why I was...
problem.
That's why I was coming back to it. I think because it's actually relevant to this case, because the second and third respondents were coming in via 16.6, but there isn't actually a route via regulation and 11 and 12. Now, no point is being taken in relation to that by my learned friend, but I just wanted to flag up, it's not acknowledging a mistake and that is irrelevant to this appeal. It is relevant because the second and third respondents, that's their route in, is through 16.5. But my understanding is, as a matter of policy, I think this is what my learned friend was suggesting, as a matter of policy, if you get the EEA permit under 16.5 through Regulation 12, you would, as a matter of course, also get your dependent.
But you'll have to do something, even if it's exercising her discretion outside the rules. But it's not a mistake, you know, like an exam question. There's simply no provisions. I don't understand why there's no provision, but I'll have to go back and read 16. It's 16.6 it doesn't provide, and this is for the stepbrothers, I take it, or stepsisters.
This is for the stepbrothers and stepsisters. So 16.6 does provide. The problem is then the route to get the entry permit. So you've got to go to 12.
Yeah. And
then 12 refers to 11.5, but 11.5 doesn't refer to the 16.6 route.
Oh, I don't think that's the gap, is it? I did wonder.
Yeah.
Right.
So I just wanted to flag that up because it is relevant, but I don't think a point isn't being taken against me on that basis.
No, that would mean if the Secretary of State had lawfully said you can't come, you're the stepbrother, that would be the end of that unless they brought a case for that. But that isn't this case at the moment.
No, exactly. Okay, so let's then jump straight into the transitional regulations, which is where I say we need to focus. I can do this very quickly, as you've seen it all already. So it's tab 5, page 15. Paragraph 1, we say that this is of central importance, the definition of EA Regulations 216. I'm going to develop that in some detail, but this is the provision that they need to be, wherever that term is used, is as it had effect immediately before they were revoked. We say that's very important. You've seen paragraph 3. There's been some discussion about the language where appropriate. Now, my reading, I think this is consistent with my learned friend's reading, although there was some suggestion that it might be broader than this. My reading of that is where appropriate is in effect a cross-reference to Regulation 4, which is where appropriate, taking into account those provisions that you are entitled to take into account for the purposes of 4.1. And then it's expressly envisaged here that, so the provisions that you can take into account are those in Regulation 6, and it's envisaged here that you can make modifications to those provisions. And then we get to paragraph 6, and you see there's a number of provisions here, a number of provisions with extensive modifications. So you see Regulation 2 is modified, a number of the other provisions are modified. Regulation 11 is not modified at all. And regulations 12, 13, 14, 15 and 16 are not retained. And that is, of course, common ground. We entirely accept that Regulation 16 has not been retained on a standalone basis. In my submission, the effect of retaining Regulation 11E.
11.5E.
I'm sorry, 11.5E. 11.5E, without any modification, is that although Regulation 16 was not retained on a standalone basis, to give the derivative right of residence, the criteria in Regulation 16 has been incorporated by reference into Regulation 11, 11.5e, for the purposes of determining whether the criteria in Regulation 11.5e are satisfied where an application has been made prior to 11 p.m. on the 31st of December. That is my core submission, that the incorporation is in effect static, so that it is incorporating Regulation 16 for the purposes of admission as it was in force prior to the 31st of December. I have 4 textual points that I'd like to make to support that construction. So the first is paragraph 1. Paragraph 1 of Schedule 3. And that provides, as I showed you, any reference to the 2016 regulations means the regulations as they had effect immediately before they were revoked. So you are retaining Regulation 11 without any modification as it had effect immediately before it was revoked. It would not, in my view, be a sensible construction to interpret Article 11 as applying as if it had effect before it was revoked, but to treat the provision referred to in Article 11 as it had effect after it was revoked.
Sorry, Regulation 11, you mean?
Sorry, Regulation 11, yes.
Say that again, then cannot say it's logical.
It would not be sensible to interpret Regulation 11 as applying as it had effect immediately before it was revoked, but to treat the provision referred to, cross-referred to in Regulation 11 as it had effect after it was revoked. Would lead to complete misalignment in my submission. And I say that paragraph 1 of Schedule 3 provides a very clear indication that that cross-reference was intended to be static in that way.
It's not intended to say would they have a right after the regulation, after the end of the period. It's simply saying before the period, what would their rights have been? And the answer is they would have had a right. They would have been entitled to a right under Regulation 16 as at that date.
Well,
or for the purposes of that application, more accurately.
I entirely agree. And you had an exchange about the use of the word would. And
well, would is the problem for,
yes,
for them, yes.
Exactly. I entirely agree. So that's my first textual point. The second is that a deliberate decision was taken.
Sorry, can I just, on your first
Yes, of course.
point, because if you look at the beginning of paragraph 6, this is related to your first point.
Yes.
It says the specified provisions of the EE regulations are.
Yes.
Or is this another point? Because then you would insert the specified provisions of the EEA regulations 2016 as they had effect immediately before they were revoked.
Yes.
And that's what you say paragraph 1 does.
Yes.
Because it's all of those. So you're not inserting words that aren't there. You're inserting words that are there as a result of paragraph 1 to make sense of paragraph 6.
Precisely. And I'll come on to this because my learner friend makes the point that I'm trying to read Regulation 16 into this provision, but that's not what I'm trying to do at all. I've got my hook, Regulation 11, as it had effect.
Yes, you're reading it as it had effect, and what it said was, as it had effect on the 30th of December, somebody who met Regulation 16, as it happened, would have been in force on the 30th of December, would qualify in these circumstances, and therefore you're saying regulation has effect. You're saying you don't need to look after to what would happen if you wanted to continue to reside, because you're looking at a different exercise at a different point in time, I think.
Exactly.
Yeah.
That is my submission. Now, I say that's enough. I'm afraid you're going to have to listen to me go on for another hour or so, because I've got lots of other points. But that is the most powerful, and I think that in a context where these are transitional provisions, I think that is a very powerful indicator of what is going on here. The second textual point I wanted to make was that a deliberate decision was taken not to modify Regulation 11 at all. That is despite the fact there was an express power to do so. That's despite the obvious and extensive references to Regulation 16 in Regulation 11.5e. It's despite the fact, and I only picked up on this during my learned friend submission, but in the grace period regulations, which were made just 2 weeks earlier, there were extensive modifications made to regulations 11 and 12. So it was something that people did turn their mind to, but a deliberate decision was taken not to modify them in this context. They could have been entirely struck out, for instance. Alternatively, it could have been modified so that it said something like, would be entitled to be admitted to the United Kingdom because the person would meet the criteria in Regulation 11.5, and then new text, open parenthesis, but only insofar as the substantive provisions relied upon in Regulations 11.5 have been independently saved by paragraph 6 of these regulations.
Or simpler, and if admitted, would have a right to reside in Regulation 6.
Exactly. But no such modification was made. The third textual point.
So, and your point is particularly pointing to the grace period regulations. Is they were modified, but also because of the number of occasions on which Regulation 16 is referred to, it's not something you could overlook.
No, absolutely not. You just have to look at regulation. It's not even just 11.5e. It's the whole.
No,
regulation.
yeah, exactly. It's
replete with references to Regulation 16. The third point, which is related, is that extensive modifications were made to other provisions, and you see that in paragraph 6. And the final point, and this is where the case has evolved quite significantly since lunch, is that the effect, but I do maintain this is the effect, and I'll explain why, but the effect of my learned friend's case is that Regulation 11.5e is redundant. Now, there was an attempt to escape from that reality. I'll explain why it doesn't really work, and it may actually assist me even further. In her skeleton, and the reference is at paragraph 30, subparagraph A, and it might be worth taking that up, just given the shift in position. I mean, this is no criticism at all. None of this is straightforward.
Sorry, paragraph 30A.
30A of my learned friend's skeleton argument for this hearing.
Is that the reply, or is that the original?
Sorry, that's the reply skeleton. So it's core bundle 73.
Yeah.
Accepted in terms that both regulations 11.5d and E were entirely redundant on her construction.
To be fair to Miss Smythe, firstly, it's the first type of discussion. Secondly, should have been bound to have been asked. We'd had discussion amongst ourselves about the returning non-EU national.
No. And I hope I was.
And if she's right, the fact that we only just thought about it after a struggle doesn't really matter. If she's right, she's right.
It's not a criticism, but I have slightly struggled with the example because my learned friend's case has been and this derives, and perhaps if we just go back to 4.1 at page 20 of the authorities file. My learned friend's case has to date, and I think this is still the primary case, you just can't have any regard, this is by operation of paragraph 4.1, you can't have any regard at all to Regulation 16 when taking one of the decisions referred to in paragraph 3. Now the case now seems to be, well you can, and that's been how the case has always been framed. And the position now seems to be, well, you can take into account Regulation 16, even though it's not in paragraph 6, if that Regulation 16 right is retained elsewhere. And I say that is just an impossible construction and impossible to reconcile with what's said at 4.1. So I get to Regulation 16 through the prism of Regulation 11, But it's just not clear to me, unless my learned friend is accepting my argument that that's how you need to read the reference to Regulation 11, how Regulation 16 as retained under the grace period regulations somehow slips in here. I entirely agree with my learned friend that these instruments are interrelated. But the instrument expressly deals with that relationship. And you can see that at 4.2. So 4.2 says in terms that where you're dealing with an application under 3.2, which is an application after the 31st of December, you need to read paragraph 6 of this regulation in a different way so that you take into account the paragraphs that are retained under the grace period regulation. So where they want you to do something like that, they say so expressly. So I maintain my submission, still I've got all my other points, but I maintain my submission that on her case as framed, my learned friend's case as framed, the effect is that this provision is redundant. But it goes broader than that because it isn't just, the difficulty isn't just for 11.5E, also is 11.5D, has the same problem. Potentially it is also 11.1, 2 and 3, which also have the same cross-references to 16.
And why is it the same problem? Because they are all retained under the withdrawal agreements. I mean, the other ones are all the Chen and the Akshira
Yeah,
ones.
well, that's what I did say potentially, but I'll retract that point because I don't need it.
No, is it because I think there are problems when the EU regulate at the EU withdrawal
Because
agreement
if you've got
itself
to read it.
maintained, because you've got to try and read them to give effect to the withdrawal agreement. I suppose.
I see that. But the other area, and I'm afraid my Lord Justice Lewis stole my thunder on this point, is I think it causes, and there's been quite an exchange about this, but I think it causes serious difficulties for the application of Regulation 3.6.
Yes, that's.
I just want to spend some time on that because in my submission, it would also render that provision redundant, entirely redundant. I actually think this is very clear, and I'll explain to you why. So, Regulation 20 continues to apply for the purpose of considering and, where appropriate, granting an application for a derivative residence card, which was validly made in accordance with EA Regulation 2016. Now, if you take up the fuller version of the regs and have a look at Regulation 20, you can see at 20B, you require proof that the applicant has a derivative right to reside under Regulation 16. Now, my learned friend, I think when pressed, well, how does this work? How does this have any force if her interpretation, her construction, which says you just can't take into account Regulation 16 because of 4.1, how does that work? And she said, well, it works because there will be people under this different regulation, the grace period regulation, that will have a derivative right to reside. But I say that just can't work when you look, if you accept her interpretation based on 4.1, which says that you just can't, for the purposes of determining an application under 3.6, you cannot have regard to Regulation 16. You just can't. That's the case. And there is no saving provision such as under 4.2, which says that you read paragraph 6 in a different way if you're dealing with an application that's made by someone that has retained rights under the grace period.
Yeah, I'm catching up on that. I've just understood it now. So 4.1 says you apply paragraph 6, and that doesn't have Regulation 16. So how can you apply something else?
Exactly. Exactly.
Because you don't have Regulation 16 anymore. You only have it, if at all, by virtue of something else.
Yes.
Pumping oxygen into it. Yeah.
Yes. My submission is that where my learned friend went, both in answers to questions on Regulation 20, and then also in her example as to how Regulation 11.5e could be used, actually both support my argument rather than hers.
Well, to finish this circle, just to make sure I fully understood it, therefore you're back to looking at the consequential regulations. There's no reference to 16 in the consequential regulations. You get it by cross-referencing from Regulation 20, and therefore you must be doing the same for Regulation 11. Is that the full circle?
That is the full circle.
Well, so Regulation 20 works by cross-reference to 16, so must Regulation 11.
Exactly. Now, I've handed up in the little pile before we started, and I'm sorry you didn't have this earlier, but I don't think that it's in dispute at all, but it's just the extract from the latest version of Benyon about the presumption that every word in legislation has a meaning. So that's at page 662 of the extract. Given the presumption that the legislature does nothing in vain, the court must endeavour to give significance to every word of an enactment. It is presumed that if a word or phrase appears, it was there for a purpose a fortiori for a longer passage or subsection, which is what we're dealing with here. And then if you go over the page, no sensible meaning. It may happen, however, that no sensible meaning can be given to some word, and in which case then it may be disregarded.
Sorry, wait a minute. Where are you?
Sorry, this is under.
Yes, I see. Yes.
And in my submission, that is not the territory we're in at all. I very much hope that the construction I'm giving the court is at the very least a sensible one, and so that works in my favour. In circumstances where my learned friend's case has the inevitable consequence that, if I'm right, that significant chunks of this instrument are redundant, and there's a sensible meaning which can be given to them, which means they're not redundant, then that latter interpretation is clearly to be preferred.
It's the sensible interpretation that bothers me. It seems to me, standing back from it, there's a problem in this way. I could quite understand everything fitting together. We're coming out of the EU, there's no soprano right. Admission and residence go together, and you'd expect them to work in the way that Miss Smythe has outlined. And the problem appears to be that they've preserved a right of admission, but for what purpose? They get off the plane, they come through Heathrow through one door, and they could be removed immediately thereafter.
Yeah. Well,
Did you say Parliament, the Secretary of State hadn't decided what to do with them, and they would probably be allowed to be here for other reasons, and the Secretary of State is entitled to say, well, it's not fair in the sort of colloquial sense, you had this right, we haven't processed your application, we let you come and see what happens.
that is my submission.
That's it, is it?
That is my submission, and there are lots of I'm going to come on to the concession because that's precisely what's happened in relation to this particular cohort that are now being given leave to remain. It's also what's happened to both the mother and her child, who we can't forget, notwithstanding the submission, and again this is not a criticism, but we're saying the submission that there's no power to do this after the first tier tribunal decision, they did grant entry permits to the mother and her child, and they're here at the moment, and I understand have now made applications for leave to remain under various grounds, including human rights grounds. It's also unclear what happened for the cohort of individuals who were determined before the 31st of December, but arrived, and on my learned friend's case would have been granted because the criteria were satisfied, but then arrived after the 1st of January, who would be in exactly the same situation, which is why the line is in they wouldn't have leave to remain. Now, there's no evidence as to what's happened to all of those individuals, but that's why the line drawing just doesn't really make sense, which is why I can certainly see the force in the point, and I think it's the high point of my learned friend's case, but it's not a complete answer for those reasons.
And it certainly doesn't lead to absurdity.
It doesn't lead to absurdity. And all of those examples I've just given you show that.
And actually, the children are British anyway. The children are entitled to be here. You're not trying to grieve out a family who've got no rights.
Well,
You're dealing with a bifurcated family where half of them are British, half of them are Nigerian, half of them are not.
yeah, it's very difficult to say that giving someone a right to enter so they can accompany their child who has a right to be here serves no utility. Even if the parents end up having no right to remain, although they may well under Article 8 grounds or something like that, but it gets the child who has a right to be here, the child who's a British citizen, it gets the child here. And that in itself is extremely important.
And not only that, the Secretary of State recognises that. The point is those children are entitled to be here and go to school here and so on, they're British. And the Secretary of State may well say, well, we'll let the parent come with them and we don't know what's going to happen afterwards. We're very busy with Brexit, but we'll have to take a decision.
And in my submission, not only is it not absurd, I say that it is consistent with the object and purpose of these regulations, which are transitional provisions. They apply to a very limited cohort of individuals who, prior to the revocation of the 2016 regulations, considered they had a derivative Zambrano right. They made an application pursuant to the process provided at the time. And now, by reason of these transitional provisions, they have a right to have that application determined consistent with the regs, the 2016 regulations, as in force before they were revoked. By contrast, on my learned friend's interpretation, there are no saving or transitional provisions whatsoever for an individual seeking entry into the UK on the basis of a Zambrano derivative right. None whatsoever. And I say that is inconsistent with the text for the reasons I've shown you. I say it's inconsistent with the object and the purpose.
Hold on. Otherwise, no transition provisions for...
Zambrano carers at all.
And that's inconsistent with what?
With the text and the object and purpose.
Well, the object... we don't know they could. We don't know what's going to happen. It might be consistent. It might not. Depends if they remove them afterwards.
Well, can I just show you? And just to might be helpful to show it to you now. I'll come back to it for external aid. But just the explanatory memorandum, which is page 30 of the authorities bundle. So it's tab 6, page 30. Now, I don't want to. I can't overplay this. There's a single paragraph dealing with what this entire Schedule 3 is intended to do. Paragraph 6 in Schedule 3 makes saving provisions in relation to the EEA regulations. The provisions continue the effect of deportation and exclusion orders made under the EEA regulations and ensure applications made under the EEA regulations before the end of the transition period can continue to be processed, including any related appeal. Now, there's only so far I can take that. My learned friend says, well, they're still going to be processed, but they'll be rejected. So but I do say that's consistent with the point that these are transitional regulations. They are concerned to ensure that people who have put in an application before this deadline can have their application processed. And it's only extending the rights for a very, very limited cohort of individuals.
Where were you reading from?
Oh, sorry, it's para 7.9 on page 30 of the authorities bundle.
Ah, yes, okay, sorry, yes. Thank you.
So my learned friend has raised a number of objections to my construction. I think I've got 4, which I'll address in turn. So the first is a textual point. As I showed you, she acknowledged, at least in her skeleton, that her interpretation leads to redundant provisions. But she has said that my interpretation does more violence than legislation because it seeks to introduce a repealed provision, i.e. that I seek to read in Regulation 16 into paragraph 6 of the schedule. Now, I've already explained to you why that's not right. I'm relying on regulation, the preservation of regulation 11.
And also the definition in
And paragraph 1.
Yeah.
Yes. So the second submission, and as I hope I fairly said, I think this is the high point of my learner friend's case, is that absent regulation 16, regulation has nothing on which to bite. And I think this aligns with the point that my Lord or Justice Lewis is putting to me. I think my learner friend referred to it as the wind beneath my wings. I won't start singing Bette Midler, but
Let us stop you.
The submission here does seem to be that one of absurdity effect. But why let people in if they can't remain? And I've made my points on that. I've made the point that it would always be open to the Secretary of State to decide, as a matter of domestic policy, to be more generous and to grant individuals who are here, because of the fact that the applications weren't processed quickly enough, for whatever other reason, to give them some form of leave to remain. And that this is where the concession is really critical. We've heard very little about the concession, and I want to spend a bit of time on it because I think it really highlights this point, but there's also something else about the concession and the immigration rules that I want to show you, which provides further support for my construction, because the premise of the concession, as I'll show you, is that the transitional regulations are in fact to be read in the way that I've suggested. Now I appreciate that there's subsequent rules, etc., but it's just another point in my favour. Can I just remind you of the position in relation to the concession? It's dealt with most neatly in my learner friend's reply skeleton argument, so we can take it from there. And it starts at paragraph 23. And this was extremely helpful. It was a point that I flagged up in my skeleton argument that there was some confusion about this, and so it was dealt with quite fully here. And so we see, if I could just ask you to read the guidance that's summarised at paragraph 24. And the key bit really is the underlined passage on the following page. Just one point, the reference to had the route not closed, that is a reference to the EEA family permit route having closed, because on the 30th of June 2021, those permits fell away, so they couldn't be used anymore, they couldn't be granted anymore, so that's what that's talking about. And what this is saying is that notwithstanding that EEA family permit route having closed, we're going to grant permits, albeit now in the form of an EUSS family permit, for Zambrano derivative rights holders. One, where you made an application before the 31st of December 2020. Two, where you would have qualified for that permit at the time. And three, and this is adding the additional qualification, which is why the respondents in this case don't benefit from it. Three, where the sponsor was resident in the UK by the 31st of December 2020 date. So that's the additional qualification. And if you fall within that concession and you're here, you can then apply for leave to remain under the EU settlement scheme. So that was as a matter of policy.
Hold on. Can I just think something through? The people who were in that wouldn't have had a right to remain. They simply would have been resident.
Well, no.
No.
Because you could have, let's imagine the facts of this case but the child was already here in the UK prior to the 31st of December, and it was just the mother and the stepfather and the children applying.
Oh, okay.
So it's, imagine exactly these facts, but child here already.
Well, the child with the grandmother who sadly dies, and the mother and the stepfather want to join them. They would get in.
Precisely. Now there's a lack of clarity, which I'll show you precisely as to how broad this concession is, and my learned friend may well come back on it in reply. But this is how I've understood it based on what is here, and I'm going to show you then how it was formulated in the rules. If you see the description of it at para 26, which is why I've understood it in the way, the concession was operated so that it applied not only to cases where Regulation 16 was continued in effect by the grace period. So not only grace period statutory instrument cases, but also where the right was being exercised in the UK at the end of the transition period, but also in some cases where the right had not been exercised by an applicant in the UK before the end of the transition period. So again, the facts of the respondent's case say that child is here. But the point is made, in both cases, however, that the British citizen needed to be here, and the point's made here and repeatedly through the skeleton, that it therefore does not benefit the respondents in this case. And I entirely accept that, but that misses, with respect, a key point, which is an interpretive one, and also a response to the absurdity point. At para 28, you see that then found expression in the rules, and you see that authorities tab 11, 178. Sorry, 198 rather. And you see, so it's called a specified EEA family permit case. That's what we're talking about. I should say these are the statement of changes. We don't actually have the rules after they implemented this, but this is what came into the rules. So A, on the basis of a valid application made under the 2016 regulations before the specified date is defined elsewhere as the 31st of December 2020, would have, had the route not closed after the 30th of June, now that's the clearest expression of that's what that term, had the route not closed, means, have been issued with an EEA family permit under Regulation 12, that's the first. Then we deal, Roman 1 is dealing with extended family members, not relevant to us. Roman 2, as a person with a derivative right to reside in the UK by virtue of Regulation 16. Well, that's the point I was making earlier. Well, the clear premise of that is that there are people applying under the EEA regulations that would have had a derivative right to reside by virtue of Regulation 16.1 that could be taken into account for the purposes of a Regulation 11 application. And all of this is then confirmed, and then you see the qualifier, the additional qualifier, which is why the respondents in this case can't benefit, which is you had to have been here. The sponsor had to have been here. The British citizen had to have been here. And all of this is then confirmed. There's an explanatory memorandum, which is at 211 of the authorities bundle. Very clearly explained 7.50 first bullet point. Now, why do I say this concession is important? 4 reasons. First, it shows that it was always left open to the Secretary of State to treat those with Zambrano derivative rights immediately prior to 31st of December 2020 more generously in relation to leave to remain. And that is ultimately what she did for this cohort of individuals. Second, for the purpose of these transitional regulations, that cohort, family members with a sponsor already residing in the UK, were in the same position as the respondents in this case, for the purposes of the criteria in Regulation 11. The transitional regulations did not make any distinction as regards the applicability of Regulation 16 through Regulation 11, depending on whether or not the sponsor was in the UK. And so the argument that's now advanced, that granting entry clearance to individuals relying on Zambrano rights would have had no utility, I say, is undermined at least in part by the fact that it has had utility for this cohort of individuals. Third, if my learned friend was right, then the concession itself and the guidance that preceded the immigration rules and the immigration rules would make no sense. It applies to a specific cohort who would have qualified for an EEA family permit. But on my learned friend's case, they wouldn't have, because you couldn't take into account Regulation 16. And finally, it also highlights that at least in 2021, when this concession policy was created, and then also in 2022, when the immigration rules were laid before Parliament, it was understood that Zambrano derivative rights holders could have been eligible for an EEA family permit where they had made the application prior to the 31st of December. Now, there is an answer that has been given to some of these points, but I'm not sure whether or not it is advanced. I'm just going to address it very briefly. I have understood my learned friend's case on the concession to be that the concession is, as framed at paragraph 26 of her skeleton argument, which is it's not just applicable to people who are protected by the grace period SI, but also applies where the right had not been exercised in the UK before the end of the transition period. So I have understood it to capture the respondent's family in this case if the child was here. That's how I've understood it, and that's the basis upon which I'm making these submissions.
But in a sense, it doesn't matter. The position is that from the 1st of January until the 21st of October, or whatever it was, for a period of about 10 months, there was a gap, and nobody knew what was going to fill that gap. So it's not odd to have rights of admission and to have a state of limbo, because even the Secretary of State didn't know what to do for 10 months.
Well, quite. Mm. And I've made that, and I'm going to say something briefly about the evidence, and I think I'll wait until I do that, because I want to make a point about that complete lacuna in evidence as to what was going on between January and October, both in relation to leave to remain, but also leave to enter.
We don't have any evidence at all about January to October, do we?
None, nothing. In circumstance where I expressly raised it in my skeleton, and subsequent evidence came in Ms. Cole's second witness statement, but it still is silent on the position pre-October. So what is said about it? I just want to show you the two witness statements. So the first witness statement of Ms. Cole starts at page 2 of the supplementary bundle. And if you go to page 8, paragraph 13, and
sorry,
paragraph 13, page 8 of the supplementary bundle.
Thank you.
And this is what first sparked my interest when I read this. So this, I should say, this is a witness statement filed in the other appeal, but it's been moved over to this appeal because it's obviously relevant.
It must be the same point, yeah.
Yes. And the point that was made here is where a person had made a valid application based on Regulation 11 and Regulation 16 before the end of the transition period, the application would have succeeded if Regulation 16 had not been revoked and the person was resident in the UK. Their circumstances were considered under bespoke entry clause. So that's how I've understood, and that's how I've presented the concession to you. That's also how it's presented in my learned friend's skeleton argument of the paragraph that I've shown you. Now, Ms. Cole, and I should say, that's also entirely consistent with the guidance and the regulations. Sorry, the guidance and the immigration rules. Ms. Cole then files a second witness statement, and that's why I think, to be fair to my learned friend and Ms. Cole, I want to address it and respond to it, to say effectively the same thing.
Where's the second one?
It starts at page 23. So she sets out the guidance at paragraph 4, and then the immigration rules. Makes the point that it doesn't assist the respondents in this case, but then appears to adopt a more, and I think this is to deal with the point that I've made, that the premise seemed to be, when you read the rules, that you could have had a derivative right under the regs. And the point that seems to be making here under B on page 26 is that the only people that could benefit from this concession, it would not be the respondent's family, if the sponsor was already here before the end of the transition period. It would also require the mother, for instance, to have previously resided in the UK and to have been exercising a derivative right prior to the end of the transitional period. That's what seems to be being said at 30B. Now, that is very difficult to reconcile with.
Where did you get that? You said 13B. I'm in the
Sorry,
second.
it's page 26. Sorry, 6B.
6B.
26, paragraph 6B.
Okay.
This is the kind of the example that she provides as to when the concession would apply. Now, my learner friend can come back to it in reply as to whether that's the position or the position in the skeleton, in the first witness statement and in the skeleton argument.
Can I help?
Yeah, of course, that would be.
Just briefly. The position in the skeleton argument is correct. I'm being told all as intended by paragraph 6 was to give some examples of others who could benefit from the concession. So what is said in the skeleton argument is the correct position.
That's extremely helpful. So then the force of all my points then remains. So
Can I understand one other thing? When we refer to a phrase that we've invented called the closure of the route,
yes.
what does that actually mean in legal terms? What are we talking about? People who applied during the grace period, people who applied before the transition period or during the grace period, or are we just referring to applications that were made after the end of the grace period?
I'd understood that on the as of the 30th of June, not only did the government stop issuing EEA permits for any purpose, it may well be that people then got some different permit.
They got a letter, as I recollect,
Yes.
instead of a permit, if they'd applied prior to the 30th of June.
Right. I also understand, and my learner friend will correct me if I'm wrong, that from that date, EEA family permits couldn't even be used to travel. They all expired on that date as well. So that my understanding was.
So closure of the route is a phrase invented to refer to the revocation of permits or the ceasing.
Well, I think that everything was. Yeah, so I'm very happy because I struggled slightly with it as well.
So closure of route, it's talking about those documents stopped being issuable. in that sense, because
Those documents being residence permits and derivative, a family
yes, exactly. So closure of the route just means those documents stopped
being issued
being issued
whenever
yes.
an application was made.
Yes, and there were some various exceptions in different circumstances that allowed people to travel if they already had one.
So if I applied during the grace period and the application hadn't been determined by the 30th of June, I thought Regulation 4 applied. But you're telling me that the Secretary of State stopped issuing any family permit after the 30th of June.
It was really an administrative decision because they no longer had any real meaning, given that we'd left the EU. So, but instead, the Secretary of State made other arrangements. So where somebody on our case would have qualified or could have had one, closure of the route means that the Secretary of State no longer issued those documents.
But
if
she
they
issued an equivalent letter which had the same legal effect.
yes, or
Well, that's very misleading, isn't it? Closure of the route made me think that they couldn't come in, but they will be able
But
to.
this is the way that it's described in internal communications as closure of the route, so that will be why the phrase has been used. That's the way it was talked about in the Home Office, closure of the route. It's not a legal term, and it's not used as such because this is all a concession. But if it would help, we can say what all the different situations where special provision was made in light of the fact that we stopped issuing those documents. But that is what happened on the 30th of June.
So the final point I wanted to make just on the issue of the concession was a point about the lacuna in evidence. And again, no criticism at all of my learned friend or those instructing her, but there is no evidence at all as to what was being done prior to the 7th of October 2021. For example, were EEA family permits being issued to this cohort of Zambrano rights holders where the sponsor was residing in the UK? Were EE family permits being issued to any other Zambrano rights holder? One of the striking features of this case is that it's quite clear, and I totally, the case law is replete with examples that mistakes can't be used to construe legislation. I entirely accept that. But what is striking about this case is there is no evidence at all about how this was being applied for a significant period of time. And the only examples that you have before this court are examples of the Secretary of State proceeding on an assumption that she absolutely did have a power to do this, all of which is consistent with my interpretation. Now, I did suggest in my skeleton that it might be helpful for the court to have an idea of how many Zambrano derivative rights EEA family permits were granted after the 1st of January 2021. On my learned friend's case, it should be 0, other than mistakes. If it was in fact, if every single case was considered on the basis that there was a power, that may well be relevant to some kind of settled practice argument. Albeit I appreciate that's very difficult. But I raised it. In the reply skeleton argument was suggested we just don't see how that's relevant and it's not readily available. But there is something quite striking about the absence of any evidence. And I don't say any of this is dispositive. It is potentially relevant to fairness issues. It's not dispositive on construction. It's potentially relevant to fairness if everybody else was being looked at on another basis other than this individual. We just don't know. But that may well be a possibility, given that the Secretary of State did not alight on this error until 2024. But it also makes it... well, that's enough. So that's my learned friend's second point against my argument on construction.
Where it's relevant, whatever the details are, things were not finalised, it seems,
That's the key
on the
point.
30th of December, And therefore, although it might be odd looking back with the benefit of hindsight and see how the jigsaw fitted together, it wasn't odd, you would say, on the 30th of December 2020, because one simply didn't know how the world was going to look.
Yeah, exactly. That's the key point. I said I had 4 points. I've actually dealt with one of them earlier, so I've only got 3. So my learned friend's third point is to draw a distinction between the fact that Regulation 16 is not retained in paragraph 6 of the transitional regulations, but it is retained in the grace period statutory instrument, or the grace period regulations. And quite a lot of time was spent on those regulations. I say it's perfectly explicable. It's perfectly understandable why Regulation 16 was retained for the purposes of that instrument, because we're talking about people that are here in the UK needing to exercise that right of residence. So it's completely different and it's entirely explicable, and you can't read anything into that. So that's my core case on construction and my response to my learned friend's submissions on construction. I just want to, as a footnote, none of us have said anything about appeal rights. There's quite a lot about it in my learned friend's skeleton argument initially, but in my skeleton argument I made the point, well, if I'm right on there being a power, then there must be an appeal right, and conversely, if I'm wrong, and so that's why, and so you can see that at 43 of her skeleton. So that's what we don't really need to address it. This court just needs to address the point about whether there's the power, and the appellate jurisdiction will flow from that. So that is part 1. I think I'm on track to finish today. So part 2 was my 3 additional factors. I say I've got more than enough on just text, object and purpose, but if you're not with me on that, I would at least hope you would accept, and I think my learned friend has accepted, that the text is at the very least ambiguous. And so, so I would suggest that it is relevant to take into account these other factors. The first, in my skeleton I referred to it as the presumption of retrospectivity. I think in hindsight it would be more accurate to refer to it as a presumption of fairness. I'm relying on the Odolola case, and the point is a relatively simple one. Prior to the end of the transition period, the applicant had made an application for a family permit to be determined on the basis of certain criteria, and if the right to have that determined pursuant to that criteria was going to be taken away, my submission would have needed to be done by clear language. In my skeleton argument, I suggested that it was at least arguable that there was a vested right here, which would have triggered the presumption of retrospectivity. I think in light of what is said by Lord Newberger at 53 of Odolola, which I'll show you in a second, that's quite a difficult argument to maintain, so I'm not maintaining that. But as I'll show you, and we'll come to it shortly, that's not the end of the story. And what Lord Newberger went on to do is to say, even if the presumption of retrospectivity strictly did not apply, there are still concepts of fairness that need to be taken into account, and that's what I'm relying upon. So if we can just quickly turn up Odolola, it's at Authorities tab 30, page 631. So this is a case that was involving a postgraduate doctor, and basic facts are that when he applied, his medical degree would have been sufficient to get leave to remain, but by the time it was actually determined, it wasn't sufficient. That's
I think she was a she.
Oh, so I'm so sorry.
It's all right.
I'm so sorry, my lady.
It's just I was in the case and I had
Yeah,
to
I think
remember
you'll
she
find
was
that
a
the
she.
judge at the end is my lady as well. But I don't think it
sorry.
matters much for present purposes.
I'm very, very sorry.
No, not a...
If we can just turn to start at 48. So this is where you have the point about there's a discussion about whether or not it can apply to rules as well as legislation, and the court says yes, it can apply to immigration rules. At if I could just ask you to read
But what are
53.
they actually seeking to interpret here?
I think it was an order.
I think it was the immigration. It was a change.
Oh, the immigration. It was the
statement
immigration
changes
rules.
to the immigration rules.
That's exactly right. Yes, yes, my lady. So if I could just ask you to read 53 and 54, which I'm sure my learned friend would go to if I didn't, and this is why I'm not taking the vested right point. But the point I am taking, if you could read on, is the one that's at 55 to 57. And this really is the core point that I'm making. Here the applicant made the applications on the basis of legislation in force at a particular time. Parliament then introduces secondary legislation, sorry, the Secretary of State then makes secondary legislation which deals with how those applications are to be determined if they were made prior to the 31st of December. And in my submission, if the legislation was to entirely take away the basis for the applicant's pending application, it should have been very clear on the face of those transitional regulations that is what it was doing. And even if I am wrong on all my primary arguments on construction, at the very least, because of the retention of regulations 11 and 12 in unmodified form, the regulations are ambiguous, and fairness in my submission points strongly towards my construction. Now, in this case, again, to be fair to my learned friend, at 59, the judge concludes that the unfairness was only slight in this case. Now I say, not so here. My learned friend has suggested that it's not unfair for two reasons. First, because there'd be no right to remain in any event, and I've addressed that point at length. And the second reason, and you were taken to several documents that preceded all of this, I think in 2019, 2020, making clear, which all made clear, that the Zambrano right was not going to be protected after the end of the transitional period. But there are two problems with that. The first is those documents say nothing about how Her Majesty's government intended to deal with applications made pre the 31st of December. It was all just about the fact the right was falling away. And the second problem is, insofar as they say anything, you were taken to the draft immigration rules, they tend to suggest, they tend to point in the direction of the date of application is going to be the relevant date. So there's certainly nothing in those that would put an applicant on notice that, I have to apply sufficiently far in advance of 31st of December, such there is no risk whatsoever that application won't be determined. That's impossible to get from those documents. So that's fairness. Second, and related, the presumption against absurdity, which really chimes with that same point. If my learned friend is right, zero transitional provisions at all for Zambrano carers. And the consequence of that is that whether or not a person receives a permit depends entirely on the officer that it's allocated to, the speed at which that officer determines the application, whether it's determined on the morning of the 31st of December or the morning of the 1st of January.
So that's just happenstance, and you say that's an absurd result.
I say that is an absurd result. And my learned friend has made repeated references in the skeleton and in oral submissions. Well, we applied on the 18th, just a couple of weeks before. But again, that is irrelevant to the issue of construction, because my learned friend's case would apply to the applicants that made their application 6 months, 7 months, 8 months in advance.
And got lost in her file.
And got lost in a file. That's why you have transitional provisions. So I say it is absurd. You don't have to take it up. It's para 30, it's the Packer judgment. I cited at 36 of the skeleton. The court will be very familiar with the principles on the presumption against absurd constructions. Just for your note, it's authority 20, tab 27, page 592. Final of my 3 factors. The external aids to interpretation, I've actually already dealt with this because I've shown you the explanatory memorandum. There's only so far I can take that point, but I say that's consistent with my construction. So that's part 1 of my submissions. Part 2 I can deal with very quickly. It's consequences of the point being raised very late. 2 points. The first is at para 46 of the skeleton, I reserved the advocate's right to make any points on the case law relating to taking a new point on appeal, specifically in relation to ground A. I don't press that point. I think my learned friend was entirely right to raise it, given it goes to jurisdiction. And I think it should be determined by the court. It is a pure point of law. And so there, I don't take the point. I'm going to come back to it to grounds 1 and 2, because I think there are some more significant issues in terms of taking new points. But there I don't take it. The second point relates to possible new grounds of challenge that the respondents may have if my learned friend is right on her construction. Now, there are limits to what I can do here. My hands are very much tied as an advocate to the court. I'm not in a position to put in a respondent's notice. But if I am wrong on construction, the court may consider it appropriate, given the respondent isn't here represented, to make comment on the circumstances which have led to the respondents finding themselves in the position that they have found themselves. And it may be relevant to both a legitimate expectation claim. I'm not going to spend a lot of time developing these. I just want to give you some headlines. They may also be relevant to Article 8 claims, which the mother and child may have in the jurisdiction. And I flag it because I think staying silent on these issues would be remiss of me. Now, my learned friend in a skeleton says there can't be...
Would they have an incompatibility argument? They might be able to say that the subordinate legislation is actually invalid because it fails to recognise Article 8 rights.
Possibly.
And in your case, it's an odd situation. 2 of them are within the jurisdiction, and I forget how many are outside the jurisdiction.
Yes.
Normally, you'd say, well, Nigeria, they can't claim, but if 2 of them are here, they might have rights, the ones who are here.
Quite possibly. And the difficulty I have is I've been sitting looking very hard at this case, and if I was here representing the respondent, I can guarantee there would have been a respondent's notice and a raft of points being raised. And I did just want to flag particularly the legitimate expectation point, because my learned friend has said, well, there can't be a legitimate expectation because rules can always change, and you always knew that Brexit was going to change. That's not legitimate expectation that I'm relying on. In my submission, there is at the very least a very powerful argument that the respondent's acts here gave rise to a legitimate expectation that her officials had the power to issue an EEA family permit assessed against the Regulation 16 criteria. That expectation derived from the 3 refusal decisions, which, as my learned friend has accepted, are all premised on Regulation 16 applying through Regulation 11. The position taken by the Secretary of State in the first-tier tribunal, the fact that following the first-tier tribunal, the appellant granted the mother and her son EEA family permits to come to the United Kingdom, the position taken by the appellant in the Upper Tribunal, the position taken initially in this appeal in the application for permission to appeal. This was a clear, unequivocal position from 30th of January 2021, the date of the refusal decisions, to more than 3 years later, 24th of May 2024, which is when Ground A was added. The state of affairs continued for a very long time, and a lot happened in that time, and it's fair to infer, and I obviously can't take instructions, but During that time, based on a view that there was a power and therefore an appellate jurisdiction, the respondents pursued these appeals. The mother and child came to the UK with an understanding that the appeals were going to continue to be pursued because no jurisdiction point had been argued, and the mother and the child have been living here, separated from her husband, and the child separated from the stepfather.
But the problem is, it has to be a legitimate expectation. And if Miss Smythe is right, and the law does not provide for the mother and child or the stepfather and children to come here, then it's not a legitimate expectation. As people would say, she was lucky to come in, and the Secretary of State shouldn't have allowed her to come in the first place. But that doesn't mean other people have got a legitimate expectation that they too will be treated in a way that breaches the law.
Yeah, I see the force in that. There's always a route outside the rules, and there's the case law. I've just forgotten the name of the Rashid case, which talks about kind of remedying its historic injustice.
It can't have been an understanding that they would have been dealt with under Regulation 16. If she's right.
Possibly.
It can only have been something much more nebulous, that they ought to do what they can to equalise the position by using other routes, because Regulation 16 on Miss Smythe's case doesn't exist.
Possibly. But the point I just wanted to make was that there may well be, and I wouldn't want that to be closed by some estoppel ground, etc., by the fact the respondent isn't here, and I'm not in a position to advance those points. That is ground A done. I think I can deal with grounds 1 and 2 in about 5 minutes, if that's okay.
Yes, thank you.
So ground 1, the key issue in my submission here, there is an issue about the direct relative, which is a point of law, but actually the court can in my submission, kind of sidestep what could be quite a tricky issue by reason of the fact that there is a second route in, which is that the stepfather is a legal guardian, and certainly on the respondent's skeleton, which was filed before he decided not to represent himself, there is a suggestion there that he may be. Now, I think the point was made, well, he just said stepfather in the application. Well, that could equally be legal guardian.
But we couldn't decide that, could we?
Well, no, exactly. But that's exactly my point. That is, and my learned friend has accepted at paragraph 48 of her skeleton that would require consideration of Nigerian local law. That point was also made by the respondent in the skeleton before he stepped away, which para 6, or bundle 38. And I can do many things, but I'm afraid I can't address the court on issues of Nigerian local law. Now, initially...
But wouldn't the appeal have to be allowed if they're right on direct relative, and then remitted to see whether there was an alternative basis? Or do we simply say, more generally, it was never taken and therefore it's not fair?
Well,
now?
That's the point that I wanted to raise. So on my reading, I'm not sure, but my learned friend can come back. I'm not sure there's a suggestion that the Upper Tribunal has actually applied the direct relative route expressly. I think the point has just been made, well, it can't be direct relative, it would have to be legal guardian. And that's not, the reality is neither are dealt with by the Upper Tribunal in its judgment in any detail. It's just assumed that one of them is...
It doesn't matter if it's a point of law, whatever the tribunal thought, if it's a point of law he couldn't be a direct relative, then even if it had been considered and allowed, it would have been wrong.
Exactly.
And the question is whether we should deal with it now, and if so, what the answer is.
Well, but the point I'm making is that the legal guardian route would still be there, but that is a question that would have to be remitted.
Yes, but we only get there if we grapple first with direct relative. If he is the direct relative, then there's no problem. If we're not going to allow them to raise the direct relative, then again, no problem. It's only if we allow her to raise it and we say she's right on it, Miss Smythe, that is.
Well,
we would remit rather than simply allow the appeal.
Yes, well, I have to accept that the direct relative point is a point of law, and the position under the domestic policy makes it very clear that a stepfather is not this is set out in my learned friend's skeleton argument, that a stepfather is not a direct relative. That does seem to be the... now, whether or not that's right is a matter of EU law.
Well, it doesn't matter because it's nothing to do with EU law. It's the definition.
Well, quite. Well,
it might be, I suppose, but it's...
I'm just trying to find a reference.
It's primary... I suppose it's whether 16.8 had to do that as a matter of EU law, had to cover the stepfather, and even if it didn't, the Secretary of State could decide to have a direct relative, not used in the lineal sense, but in a broader sense.
So, the reference in the skeleton... on ground 1, which is the guidance at 47, page 28 of the core bundle. Again, to be fair to my learned friend, sets out the guidance, makes the point that there's no definition.
So are you page 47 of the core bundle? Because that's your skeleton.
28, sorry, 28, paragraph 47, page 28.
Yeah.
47 of your skeleton, which sets out the guidance, which makes the point there's no definition. But this is how it has been applied. Now, I'm just...
And there's no case in which that's been tested.
Not that I'm aware of, but it's not something that I have focused on. It's not something that I've focused on in preparing. I focused on ground A. I'm very happy to look at it overnight, if it's a point the court would be assisted with. But that is.
My instinctive reaction to the whole thing about Zambrano
Yes.
was that children being forced to leave the UK and the EU,
Yes.
and therefore they had to stay with a parent. But if you've got a happily married couple and it simply happens to be the stepfather, not the first father, and the stepfather is with the mother and looking after the child,
Yes.
it's jolly odd to say in those circumstances the British child has to lose out
Yes.
because her father was sadly killed and her mother married again, which is I think what happened. Or father died and her mother married again.
Yeah.
I mean, the child might have been 2 months when the father died.
No, I
might
can
only have known the stepfather.
I can see the force in that. So I'm very happy overnight to see if I can find any case law on the point. The point I was going to, there are obviously 2 routes, but I can see the issue. Given the Upper Tribunal doesn't actually say on which route the Upper Tribunal went down, whether it's legal guardian or direct relative.
That's why I wonder. I mean, the Secretary of State didn't say in the first tier
No, well,
tribunal or in the Upper Tribunal.
Didn't say in
the stepfather fell outside the direct relative.
Didn't say in the refusal decision. But it's actually stronger. It's actually stronger than that, my lord. If you go to para 13 of the Upper Tribunal decision at page 106. Look, and this may well be the shortcut through it, even though obviously it being a point of law is one of the factors you take into account in deciding whether or not a point can be raised late. But there are other considerations as well, including of basic fairness. But if you look at 13, so that's where the judge says, I need to take this decision again myself. The Secretary of State's representative was invited to make any representations, didn't, said I had nothing further to add. The respondent's representative made it very clear the only reason for the refusal was the application of the primary applicant. We then have the reasoning at 24, and part of the reasoning was it was not contended on behalf of the respondent that the appellants could not benefit from the above-mentioned regulations for any reason other than that advanced by the ECO in the decisions under appeal. This may be one of the very rare cases and again, I can't make submissions on the underlying circumstances of these individuals. If I was acting for the respondent, I would have come with witness statements explaining the impact of these decisions, the impact of the delay, etc., of the separation. This may be one of the cases where fairness dictates that a new ground of appeal would be inappropriate in circumstances where the Secretary of State had 3 opportunities to take this point and didn't, and in circumstances where
the FGT took the point of its own volition and shouldn't have done.
yes, exactly.
And where it has no effect on anyone else at all.
Well, that's what I was just wondering. And that's what. Yeah, this decision doesn't. May well, if you decide to go off and decide the direct relative point, that could. But you don't need to determine it. If you were just to decide that this doesn't stand for any proposition in relation to direct relatives because it's just not dealt with. So I entirely agree that it doesn't have any.
And I must say, I wonder whether, whichever judge granted permission, I wonder whether he'd even thought about the second tier criteria and appreciated the significance of this in the great scheme of things.
Well, I have to say I didn't, and hence my focus on ground A. And I think also that was certainly the basis of the advocate to the court being appointed, was not to deal with the direct.
I can't remember the appeal skeleton, the permission to appeal skeleton, whether that really did raise this issue. And if it did, and I granted permission, then I must have been aware of it. The fact that I hadn't appreciated it is important, and neither here nor there.
Ground 2, if I may, just very, very quickly. Look, this I can deal with very shortly. This is effectively a reasons challenge. I've shown you paragraph 24. The Upper Tribunal has made findings of fact, and all of the case law on the appropriate role of an appellate court when dealing with findings of fact, perversity, etc., would therefore apply. Now, my learned friend very fairly took you to initially suggested, well, there was no evidence at all to support those findings, but then took you to paragraphs 16, 19, 20, 21, 23 of the witness statement. Now, none of them say in terms, apply, like in the language of the test. I say it was absolutely open to the Upper Tribunal to draw inferences from those facts. And that's what the Upper Tribunal, and I have to say they're not kind of out there inferences. It's pretty obvious, and they follow from those paragraphs. And
It's 2 things. It's the inference from the close relationship and the absence of any suggestion of any other evidence to contradict that.
That's all I have on ground 2.
Yeah.
That's the point. I hope that's been of assistance.
Thank you.
If there's anything else, I'm very happy to.
Anything else? No. Right, thank you very much. We'll stop there and start again at 10:30 tomorrow. Are you able to give any indication as to how long you think you might be?
My lord, depends on how much background information you want. If you want me to skip that, that's just about an hour or so.
An hour, okay. Sarah?
My lord, I'm just intending to deal with the issue in the Ahmad appeal, which doesn't overlap with Rafiu. Effectively, the Regulation 21 application.
If Miss Smythe is wrong on her interpretation, then 2 things needed to have decided. Was an application made, as a matter of fact? And if so, was it a valid application? We can't decide that. That would have to go back if you lose.
Yes, my lord, and that's one thing that will form part of my submission.
So what do you think it will be, about half an hour?
My intention was 30 minutes. Yes.
Okay, thank you. So 10:30 tomorrow.
All right.